Hello dear students, my name is Sitarama. I am currently Vice Chancellor, Global University. I discussed in Module 1 why we need a southern perspective of human rights when we teach human rights in a country like India. And in Module 2, I would like to discuss what challenges do we face in curricularizing human rights issues in our higher education context. I would present my argument in 4 major themes. First of all, I would like to argue about how to make human rights inclusive in conceptual sense when we teach human rights in a post-colonial society. The second point I would like to say about is how can we explain the global popularity and the spread of human rights and of course law in a way that would be meaningful for our context. The third major point I would like to speak about is how can we make sense of everyday conflicts that we seem to be encountering in our societies, which are represented as certain forms of violence, which is very clearly a violation of human rights undoubtedly, but are there more serious matters to look beyond the human rights violations question? I would delve into that matter as my third point. And finally, I would like to present why there are various forms of sufferings that exist outside the purview of conventional human rights thinking and why that needs to be brought into the framework of human rights discussion in our societies. Let me therefore begin with making sense of the story of human rights in our context by making human rights inclusive. When I am saying making human rights inclusive, I am suggesting the existing concept of human rights is necessary but inadequate. In other words, we need to expand the notion of rights. We need to make human rights more visible and meaningful in our context. So which means it requires a reinterpretation. And the reinterpretation I would present through 2 important approaches. The first one is how to understand what does colonialism mean to our contemporary understanding of law and rights in India. When I am saying what does colonialism mean to us, I am not suggesting only the issue of economic plunder or political subordination. These 2 issues have been very widely discussed over the decades, and of course we have a clear understanding as to the implications of both economic plunder and political subordination. But there are very many other issues that both post-colonial studies as well as cultural studies brought to make us understand that the significance of colonialism in contemporary context is its continuities in meaning-making process. In other words, its epistemic influences, its methodological influences in the way we seem to be thinking about problems or solutions, or thinking about how to find a resolution to a variety of social conflicts. And I think that's where I would like to deal a little more in terms of understanding what is the significance of the colonial to our discussions of contemporary human rights and law debates. One key point with the colonial influence in understanding law and human rights in the contemporary is making the distinction between law as a norm and law as a strategy. Professor Bakshi, in a variety of contributions on colonialism and law, repeatedly pointed out an important fact as to how the colonial governments brought law into the colonies. The colonial governments brought into the colonies the idea of law, not so much to empower the subjects of the colony, but more to enhance their control and regulation of these populations. that actually created a particular way of understanding law, or what another South African anthropologist very provocatively called lawfare. What lawfare has done in the colonial context is to make people suspicious about what law can help them. It is true that law is always a double-edged sword. It helped in terms of empowering those who are on the margins, but at the same time, it is simultaneously a tool for control, regulation, and also subordination. And this duality of law and its institutional edifice that emerged from 17th, 18th, and 19th centuries in our colonial context plays a very important role, and that we must understand. So therefore, the continuities of colonialism is not simply only the existence of laws on the statute books, or the continuity of a particular institution without really major changes that has undergone over a period of time, but rather the continuities are in the modes of thinking. The continuities are in the way that we continue to think about the social problems and the possible solutions that we could think about. And I think that to me is a very important point to underpin what colonialism means in contemporary understandings of law and human rights. The second point, of course, to see is the analysis of law and constitutionalism in Global South. So in other words, the expansion of law and legal edifices that we have seen over the last 60 odd years of independence is an important testimony to see the expansion means we are continuously reinterpreting and therefore giving different meanings to a variety of legal concepts that we have borrowed from, say, common law tradition. The spread of law and constitutionalism in Global South is also equally important point to understand the influence of the colonial in explaining the contemporary. The fact that over the last 60 odd years of independence that a lot of law and constitutional mechanisms have expanded, the fact that we continue to find legal solutions to social problems indicate, number one, that we continue to deploy similar methodologies as modern colonial state did, and number two, however, is to reinterpret the possibilities through the new constitution. So in other words, the contemporary constitutional rights, the fundamental rights I mean, which obviously influence a number of questions very differently compared to what the colonial context was. And I think those reinterpretations are equally important in terms of understanding what does the colonial mean to the contemporary. In a similar way, the second point I would like to underscore for making human rights inclusive in our context is to look beyond the conventional approach. And what I mean by conventional approach is human rights conventionally has always been seen as a matter between the state and the individual. The individual is the abstract liberal individual citizen subject. So in other words, the gender, the caste, the race, the other questions are never attributed to the individual. So the relationship between abstract individual and individual's capacity as a rights-bearing citizen in negotiating certain entitlements vis-a-vis the state was the conventional frame, and which continues to, of course, predominate the Euro-American model of thinking about rights. But the social context in our society and the kind of issues that we witness necessitate our understanding of human rights beyond a conventional state individual framework. It is true that even in the Euro-American context there is a great rethinking on this point over the last couple of decades. In our own context, the social conflict, for instance, the caste violence or the violence against Dalits more particularly, or the caste prejudice, that is in the way the speech or the other forms of action happens vis-a-vis the lower castes, domestic violence, that is violence against women, very broadly speaking, were not seen as human rights questions initially, but they became human rights questions when movements, women's movement, Dalit movement, and so on, actually highlighted these questions as human rights questions. In doing so, they already reinterpreted the conventional framework and expanded it to include violence in private sphere, which was not a conventional liberal way of looking at human rights violence question. And I think that is very important, and this is a contribution that many southern societies have done in reinterpreting the human rights approach. Another very contemporary issue for us I would like to highlight in saying about going beyond the conventional approach is looking, for instance, the concept of minority rights. Minority rights were seen in the constitutional framework in India as something that existed as constitutional pluralism. So in other words, we have a constitutional framework which created fundamental rights, but within fundamental rights, we also have a particular set of rights as minority rights, which recognize certain privileges which sometimes may not be in tune with the core values of fundamental rights, but they coexist. For instance, personal laws, and which is a very long-standing debate in India. So the minority rights framework imagines minority as a cohesive group. And what happened over the last decade in India is lower caste movements that really expanded in each major religious fold in this country, whether it is Hinduism, whether it is Christianity, whether it is Sikhism or Islam. You see lower caste movements in each of those religions. Well, the significance is very clear. All the minority religions who are considered as minorities as a cohesive group now witness new forms of contestations within, seeking newer forms of recognition, and therefore a newer way of thinking about redistribution question. And I think that to me is a very significantly important development and an expansion of the way human rights has been looked at. That brings me to the point which I mentioned as my second theme. The second theme of understanding the challenges of teaching human rights in a country like India is how can we explain the global popularity and spread of law and human rights over the last 50-60 years. I think that's a very important point to reflect on. One simple and technical answer could be that all the modern state system, that is the modern United Nations system, is a state-centric model. So number one, all of them need a particular kind of constitution, and number two, they need a particular kind of governance model. And that uniformity at one level is adequate to explain the global spread of human rights and its popularity. But that's a technical way of answering the question. We also need to account for constitutional divergence. While the state form may be uniform, there is no single democracy that is also uniform. There are presidential forms, there are semi-presidential forms, there are parliamentary forms, and within parliamentary forms there is no uniformity of any kind. There may be some eludings of commonalities, but that simply is metaphorical. There is no real continuity of anything in borrowed models or otherwise between these democracies or the modern states. So as a common, they will have a constitution. As a common, they are a territorial nation state, and beyond that, obviously, the forms of constitutionalism and governance structures, there is great diversity. So while there is a spread of human rights because it is a method by which international community adapted human rights and popularized, the way they get internalized in all these national states, there is great diversity. The way they get rooted and then represented, gain popularity in each of these societies, there is great diversity. But I think it is important that we recognize the common state system and the methodology that they follow in making the international human rights law is an important vehicle by which the popularity of international human rights happened. It is also important to recognize that all constitutions nowadays use the language of rights. Compared to the 19th century constitutionalism, where the rights language emerged as a new way of representing social questions, we see in 20th century a complete adaptation of rights language in representing all individual concerns vis-a-vis the state and vis-a-vis the society. And I think this transformation of rights language, or as a scholar called rights talk, is a very expanded way of thinking about our everyday context through the language of rights. And I think both this cultural formation of thinking through the rights language, as well as this institutional form of nation states and the international lawmaking, are two critical points that will explain why human rights have become popular across the globe. What kind of challenge does it pose? As I said, the challenge once again is in terms of understanding constitutional diversity and the way the human rights get internalized in each of this society, which I think is an important way that we should look at our own social context. Let me now come to my third theme of challenge in teaching human rights in a post-colonial society. This is related to what I would call post-colonial disorders. I am borrowing the term from Jean and Jean Komarov, who reflected in an edited volume on various forms of customary and cultural conflicts with modern constitutionalism in various parts of Africa and Asia. And I think it's an important point to understand. While these conflicts are represented as disorders by modern state, they probably indicate a more deeper problem, a more deeper philosophical set of questions that we need to understand. And so I would say, therefore, if we want to teach human rights in a society like India, we must understand better what is represented as this disorder, right? So that, I suppose, is what my focus in this part is. Often this conflict between tradition and modernity, right, this custom versus constitution, or this cultural or rural settings coming in conflict with modern state, is a very interesting, intriguing and consuming phenomenon in Indian public sphere. I suppose anyone who watches TV or any such news media would be very clearly familiar with a variety of stories where certain forms of social power continuously come in conflict with the modern state. It could be religious leaders, it could be caste leaders, or it could be other forms of minority leaders who continue to defy the sovereign position of the modern state. And that leads to, of course, certain kind of social conflict, and then it often gets resolved technically, if not very through coercive means of the modern state. While, of course, we must recognize these are phenomena, the manifestations of certain forms of conflict, the deeper side of it needs a little more exploration. Often this conflict between tradition and modernity is seen through naming and shaming. So in other words, those who are caste leaders or religious leaders who are in tension with modern state often get named as belligerent or unlawful or such names. That is true. I think the acts basically in modern constitutional society require to be said so. But then how should we really work towards transforming those structures of social power? Can we really think about making interventions at there rather than only confining to prosecuting the manifestational forms? And I think that obviously is an important question to understand, and I would not be able to get into the details of that, but hopefully as we discuss we will see in subsequent modules some manifestations of how we may approach these kinds of social conflicts between the conventional forms of authority and modern state. One simple methodological point a feminist scholar pointed out, however, I would like to place it for conversation, that would be the work of Ayelet Shakar, who in her work Multicultural Jurisdictions tried to raise a particular concept called what she called transformative accommodation. The point, however, of course, to recognize about transformative accommodation is that you are not exonerating or you are not condoning the acts of social authority defying the modern state sovereignty, but rather recognize, deal it, if it is a crime, as a crime, if it is a disturbance, as that act as per law. But subsequently, there is need to understand how to give a kind of negotiated space for the social authority in such a way that gradually we will transit into a more better, more accommodative, less belligerent social authority formations in these societies, which I think is an important point, and we will see more clearly with examples in the next module as we go. Also, another area where we continuously see the problem of conflict is the issue of whether we should have uniform courts or we should permit legal and constitutional pluralism. In a society like India, it is a issue that gets repeatedly surfaced in various kinds of matters. We are very familiar with the Shabano case. We are very familiar with subsequent issues that came up in such matters, and occasionally the apex courts expresses its deep concern of creating a uniform code. So it is an issue. Should we harmonize all personal laws into a single constitutional frame, or should we hold constitutional pluralism and engage with what I mentioned as the feminist scholar's point, transformative accommodation process? Can we do transformative accommodation that leads to uniform civil code? Looks a little instrumental, but I suppose is a problem both theoretical as well as practical for talking about it. But one thing that we should recognize is the legality of modern post-colonial society is far more complex, and it has multiple forms of challenges to the legal order, and that needs to be understood while of course being dealt in an everyday context of asserting state sovereignty. The final point in this particular context I want to say is the newer forms of epistemic challenges that modern constitutionalism faced in recent times. I would illustrate this point with the point of indigenous rights. There has been a lot of discussion ever since 1970s when Native Americans and a variety of native First Nation people raised questions about their rights, and international human rights law very reluctantly debated over 3 decades in order to pass the Declaration on Rights of Indigenous People in 2007 finally. The point, however, the indigenous rights question raises is what would be the significance of indigenous modes of thinking and indigenous traditional knowledge, and whether that could be accommodated in the existing constitutional frameworks as we know in the modern law. The answer seemed to be a far more difficult one because the categories of thinking of indigenous knowledge, for instance, a concept like public sphere, there is a particular way by which modern law defines it, but the indigenous people, at least some of them, seem to be thinking that they think the public question very differently in their context, which has a clear implication for notions of property, notions of ownership, notions of how we should utilize or reuse or representational rights question. And I think those are very significant in post-colonial societies, and we need to take special heed to that kind of question. Finally, the point I would like to say about the challenges in our society, teaching human rights in our social context, is I would use the work of Bakshi, the phrase that he brought into popularity is taking suffering seriously. In other words, all post-colonial societies have deep inequalities, economic inequalities, marginalization, disempowerment, various forms of social oppression. As I already said, a variety of them don't stand to be a rights violation issue in conventional wisdom sense. We need to really continuously engage, represent, and frame them into a rights language if we were to take the rights question seriously. So in other words, taking rights seriously in a post-colonial context would be translated not so much about the legal question of law and rights, but rather it is about taking the forms of suffering and their representational possibility in the language of rights. And I think that is an important contribution of Professor Bakshi in this particular case, and that I would like to deal very quickly as an important issue in understanding human rights question in post-colonial societies. In India, it goes without saying that there are a number of people who are technically referred as people below poverty line, but you could also consider them as people who have no capacity to exercise citizenship rights. This is the term once again Professor Bakshi introduced in a work called Right to be Human. So in other words, we need to recognize more fundamentally a person's right to be human as a precondition to exercise human rights. And this foundational aspect of right to be human is a transitional process which is on the shoulders of state in making these people who are disempowered to become human. And I think that transitional foundational responsibility is on the shoulders of state, and that is something that we need to bring it into the conversation in talking about human rights in our context. The second point to highlight in this particular mode of thinking is to recognize that the people who are outside the constitutional frame, in other words, metaphorically of course, those who are not having capacity to exercise rights, what are the ways by which they can negotiate, demand, struggle for their welfare? More recently, a somewhat contested theory has been propounded by the political scientist and historian Partha Chatterjee, whose work, The Politics of the Governed, and the subsequent work demonstrated that what we should see as the struggles of the people who are outside the framework of citizenship is that they only have a very painful, very agonistic, very contingent possibility of negotiating welfare. In other words, they cannot easily get their rights recognized either through the forums of courts or any other modern institutional framework except symbolically. The substantive welfare, in whatever little that could be, is only through the medium of negotiation on the site of politics. So in other words, they, in the context of electoral battles or such other situations, will come together in a very contingent way and then try and seek welfare of a particular kind. And if everything falls in place, that there is an interest question for a political party or the leader around, if there is a possibility that these demanding groups can come together as a single vote bank or demonstrate the potential of it and so on, I am just metaphorically suggesting the possibility of thinking about it, then and then only they would be able to manage their welfare question. So in other words, seeking rights is not a straightforward matter in India for many people who are outside the modern constitutional citizenship capacities. And I think that's a question which we need a real sort of inquiry into. The last point I would like to say in the taking suffering seriously is the issue of economic and political transition of Indian society. Over the last 2 decades, the Indian state and the industrial class has emphasized on growth-oriented policies and embarked upon rapid developmental strategies. There is no doubt that India has made a lot of economic advancement and progress, with about 7 to 8% of growth recorded. The question, however, from a human rights vantage point would be how these developmental policies are both framed as well as perceived as tensions or possible ways by which the human rights question is brought to bear upon. I think that is the issue on which we need to really put a closer scrutiny with regard to developmental projects in India. It is not to say that human rights must be seen as an obstruction to development. That would be a very wrong way of framing the question. Rather, we should try and see how the development can be seen as something that would at one level accommodate and respect the existing constitutional and human rights standards, and of course at the same time work towards a growth-oriented progress model. And I think that balancing act is squarely the responsibility of the state, and issues of this nature obviously need a closer scrutiny of the nature of projects, what is the way the diligence question is followed by the state agencies, and what is the way the corporate industrial actors deal with their social and human rights responsibilities in the implementation of these projects. It is important any modern progressive civilized society take the questions of rights very seriously in the particular contemporary context, not as something that would be respected once we become developed. Human rights is a question of here and now, not for a future promise. And I think that's an important question that we need to take note of in looking at taking suffering seriously and its rights-oriented representation in our context. With this, I would conclude this module to say that there are 4 challenges that I have identified and presented to you as to why, if we are teaching human rights in a post-colonial society like India, we must take serious note of them. Thank you.